Welcome to the debate. We are diving into a really crucial constitutional question today. Just how far does the 24th Amendment, that's the anti-poll tax amendment ratified back in 1964, how far does it actually reach in protecting the right to vote today in the modern era?
Right, and it's important to remember the 24th Amendment was, well, a very specific legal tool. Its text explicitly outlawed paying a fee, a poll tax, or other tax to vote in federal elections. And it directly overturned that earlier 1937 Supreme Court decision, Breedlove v. Suttles, which had previously allowed states to impose those kinds of taxes.
Exactly. In that historical context is, I think, precisely what opens up our debate for today. Given that the original intent of the 24th was to get rid of disenfranchisement based on someone's inability to pay, the question becomes, should we recognize these modern, non-fee-based voting requirements? Things like, say, the cost of documents needed for a voter ID, or travel burdens to get to polling places, maybe even lost wages from waiting in super long lines. Should we see these as functional modern-day poll taxes? Do they actually violate the spirit and maybe even the legal force of the amendment?
And that really is the core question, isn't it? My position is that the 24th Amendment is quite narrowly tailored. It prohibits literal taxes and specific fees linked to voting. These other structural administrative burdens, while I absolutely agree they are undeniably harmful, especially to low-income voters, they're for fundamentally different kinds of legal problems, and they probably should be addressed primarily through the much broader scope of the Equal Protection Clause of the 14th Amendment.
And I'm going to argue the opposite side, that these functional economic burdens, which really do operate as material substitutes for the old poll tax, they fall squarely under the 24th Amendment's prohibition, specifically against any equivalent or milder substitute, as the court put it. The mechanism of oppression might change, sure, but the effect, denying the vote based on income, that stays the same. So let me start just by recentering the economic reality that the 24th Amendment was trying to fix. It was a necessary, very targeted response to Jim Crow practices designed quite explicitly to stop African Americans and also poor whites from voting by, well, putting a price tag on it. The fees were inherently regressive.
The goal was clear. Remove that immediate financial hurdle. And, the cumulative nature of the poll tax often meant that if you missed paying 1 year, voting the next year became exponentially more expensive. It effectively froze millions of people out of the political process for purely economic reasons.
Right. And the Supreme Court acted pretty quickly to affirm the amendment's core principle. That was in the 1965 case Harmon versus Forsenius. The court was very clear. States could not impose any equivalent or milder substitute or any material requirement on a federal voter simply because they refused to waive their constitutional immunity from the poll tax. So the principle here isn't just about the word tax, it's really about imposing a cost that restricts the franchise.
But the key there, I think, is that the cost must be imposed by the state, specifically for the vote itself.
Well, let's try to quantify the modern cost then. The historical poll tax, as you said, often $1.50, maybe $2. Adjusted for inflation, that's roughly, $12, $13 in 2020 dollars. Now, think about the requirements for getting a supposedly free photo ID under some of these strict state laws. If a low-income voter doesn't have, say, a birth certificate or other proof of citizenship handy, they might have to pay $15, $20, sometimes even $30 just to get a copy.
That is certainly a cost. I grant you that. But I do see a distinction. The explicit text of the 24th Amendment, it prohibits denying the right to vote by reason of failure to pay any poll tax or other tax. And courts, by and large, have been highly resistant to expanding that word tax to cover these more general, indirect costs of compliance.
But the constitutional goal is ensuring the franchise isn't denied because someone is poor. Why should the exact method matter so much? We know that low-income eligible voters, look at households with incomes below $20,000. They vote at significantly lower rates. These financial hurdles, they force an impossible choice. Either pay a price they genuinely can't afford just to comply with administrative rules, or simply don't vote.
Well, from a judicial perspective, the mechanism really does matter.
the courts have pretty consistently treated the cost of complying with generally applicable requirements like getting an ID or even traveling to a polling place as merely incidental to the election process. They're not seen as fees paid directly to the state for the ballot itself. Look at the Fifth Circuit in that Texas photo ID case, VZ v. Abbott. They explicitly characterize the cost of getting birth certificates as an indirect cost, something that fell within the state's, permissible ability to regulate its elections, not a poll tax violation.
See, that classification of these costs as incidental, that's precisely where I think the legal interpretation fails the low-income voter. I mean, I fundamentally disagree with calling a $30 document fee plus maybe 4 hours of lost wages to go get it incidental. In legal terms, that often gets brushed off as de minimis, right? Too trivial to bother with legally. But for a citizen who's genuinely struggling to make rent, these are critical material costs.
That's an interesting point, though I guess I would frame it a bit differently. The state's interest in, say, ensuring secure modern elections or preventing voter fraud often gets weighed against these burdens in court, and often it's seen as outweighing them. Think about Crawford v. Marion County Election Board. In that case, the Supreme Court found Indiana's interest in preventing voter fraud outweighed the burden of getting a free ID. The courts essentially said, look, unless the expense is a fee paid directly to the state to cast a ballot, the costs of compliance are just a consequence of living in a regulated society. They're not a constitutional violation of the 24th Amendment specifically.
But we really need to look beyond just the label of tax and focus on the functional reality here. The costs tied to these modern requirements are far from incidental for the poor. Let's talk about time for a second. Time is money, especially for hourly workers. Polling place closures and consolidation, we see this happening a lot. It leads directly to these excessive lines. We've all seen reports, waits of 5-6 hours or more in certain precincts, often in minority or low-income areas.
Which is, I agree, a severe administrative failure, no question.
It's more than that. It's an economic barrier. If a low-income worker has an inflexible job schedule, they are forced to lose hourly wages, at least the federal minimum of $7.25 an hour, often much more, or they risk their job entirely just to wait in line. A 4-hour wait, that could easily be $30 or more in lost income, not even counting transportation costs. That lost time, that lost income, it is a quantifiable, regressive economic barrier. It fulfills the very definition of a cost the 24th Amendment was explicitly designed to get rid of. You could argue it's a tax on their labor, required just to vote.
I'm still not quite convinced by that line of reasoning, mainly because it seems to stretch the concept of tax perhaps too thin. If we start using the 24th Amendment to litigate things like lost wages and bus fare, where does it stop? We risk making the specific constitutional language almost meaningless.
But Harman itself, I think, suggests a broader scope for the 24th Amendment, one that doesn't require a direct cash payment to the state. Remember, Harman focused on Virginia's alternative, a residency certificate requirement. It applied to all voters who declined to pay the state poll tax, and the requirement was struck down precisely because the administrative hoops involved, getting it notarized, filing it 6 months in advance, were deemed a material requirement imposed because the voter refused to pay the tax.
I agree the court used the term material requirement, but the key relationship there, as I see it, was causality. That certificate requirement existed because the poll tax existed as an option. Modern ID laws, on the other hand, are generally applied across the board, ostensibly to secure the election process for everyone. You don't face the ID requirement because you refuse to pay some other tax. You face it simply because you're a voter in that state wanting to cast a ballot.
But the complexity of modern requirements, like, as we've discussed, making low-income voters travel long distances to understaffed ID offices with very limited hours, or demanding complex documentary proof they might not easily have, that functions exactly like that high-cost administrative barrier in Harman. It's a functional substitute. It effectively disenfranchises voters who cannot afford the time or the expense, just like the original poll tax did, even if the mechanism looks different on the surface.
That's a compelling argument when you focus on the effect, I'll give you that. But relying too heavily on the 24th Amendment here risks, frankly, judicial failure. We've seen this play out. The Ninth Circuit, for instance, in Gonzalez v. Arizona, ruled explicitly that state ID laws are not a Harmon-style material burden. Why? Because they apply to all voters and aren't imposed solely because someone refused to waive immunity to a poll tax. The courts, for the most part, just seem unwilling to make that interpretive leap with the 24th Amendment.
And yet, we see the systemic effect of these economic barriers operating as pretty clear voter suppression, regardless of how you label it textually. The data, I think, confirms the cost-imposing intent, or at least the foreseeable effect. Look at Texas. Between 2012 and 2018, the 50 counties with the largest increases in minority populations closed, 542 polling sites? That's not random. Similarly, after the Shelby County v. Holder decision gutted parts of the VRA, Alabama, which had implemented a strict photo ID law, promptly moved to close the MV offices, disproportionately affecting Black residents. They closed offices in 8 of the 10 counties with the highest percentage of Black residents.
And that data is powerful evidence, certainly, of intentional discrimination or, at minimum, disparate impact based on race and perhaps socioeconomic status. Exactly. It's intentional action, or at least predictably discriminatory action, that imposes huge economic costs, transportation, time off work, that are functionally equivalent to a tax on poor citizens, particularly minorities, who now have to travel much farther or jump through more hoops. This systematic creation of cost barriers, I argue, violates the core anti-oppression intent of the 24th Amendment, which was meant to eliminate any fee or any substitute for a fee that restricts participation based on inability to pay.
Okay, but I still come at it from a slightly different legal angle. The very serious hardships you're citing, whether they relate to polling place consolidation, ID law access, voter roll purges, what have you, these are overwhelmingly and often more successfully litigated using the Equal Protection Clause of the 14th Amendment, or what remains of the Voting Rights Act. Why? Because those legal frameworks are designed to focus directly on discriminatory intent or discriminatory effect, which is exactly what your data points towards. The Equal Protection Clause feels like the better legal tool here because it allows courts to tackle discrimination based on wealth or race head-on, without needing to perform the arguably more difficult task of convincing a court that lost wages or travel costs somehow equate to a tax as defined in the very specific language of the 24th Amendment. The 24th, textually speaking, seems like a rather blunt, maybe even narrow instrument for what are often subtle, complex administrative problems with discriminatory outcomes.
But when the total cost of complying with voting requirements, whether it's paying for documents, navigating incredibly complicated registration systems, or just enduring these excessively long lines that cost wages, when that cost functionally exceeds the financial value of the original poll tax, the effect on low-income voters is identical: denial of the franchise based on their inability to pay. The 24th Amendment, I believe, must be interpreted dynamically, with an eye towards its purpose, to protect the voting rights of the financially insecure today. It shouldn't be relegated to addressing only historical fees that, you're right, largely no longer exist in their old form.
Well, intellectual charity is important here. I think we both agree that the disenfranchisement of the poor through these kinds of structural means is a critical ongoing issue that absolutely demands constitutional scrutiny. Where we differ is on the best legal avenue. I maintain that the most effective legal battles against these barriers will likely continue to rely on the Equal Protection Clause, which directly addresses the socioeconomic and racial discrimination often at the heart of the problem. It just seems to offer a more robust and frankly judicially accepted path than trying to fit the broad concept of a voting burden into the narrow textually defined ban on a tax found in the 24th Amendment.
So it sounds that we agree entirely on the severity of the problem, the reality of the economic barriers facing low-income citizens who want to vote today. But we disagree fundamentally on whether the 24th Amendment itself has the, let's say, interpretive muscle or the historical scope to fight that problem directly, or if we must rely primarily, maybe solely, on the 14th Amendment's broader protection against discrimination.
Exactly.
And I think this discussion really highlights the ongoing challenge of guaranteeing the franchise in practice, when the right to vote is contingent not just on the words in the Constitution, but also very much on economic means, administrative procedures, and, frankly, political will. There's clearly much more to explore in how these different constitutional texts intersect, or perhaps fail to intersect, with modern election law realities.